What happens when law, business, and life collide? Each week on Lead Counsel, your host Tom Tona will take a deep dive into topics related to the law, the business of law, and life. There will be insightful discussions with industry insiders, experts, and thought leaders making significant contributions and meaningful differences in their fields of expertise. Tom is the founder and managing attorney at TonaLaw. He has been a practicing attorney since 1994 and the leader of TonaLaw since it opened in 2001. The goal of this podcast is to provide you with free information on law and the business of law, and to give you actionable tools related to each of these areas. Now, here's Tom.
Hello, welcome to the Lead Counsel podcast. My name is Tom Tona. I'm here with Juliet, my good friend, my marketing person, and my sometimes co-host. What's going on, Jules?
Hi, everybody. It's going good,
Yeah?
Just another day in paradise.
Just another day in paradise. So I want to first take the time to say thank you to everybody for tuning in, listening, downloading, giving us feedback, and to encourage you to do that more. And if you have specific things that you want addressed on the podcast, please, by all means, contact us. We'll tell you how to do that at the end of the episode. But thank you again for tuning in wherever you listen to podcasts and for the feedback that you're leaving. Today's podcast, I'm excited about it. We get many calls on a daily and weekly basis that are repeat of the same theme of type of question that we get, right? So we get these frequently asked questions, especially in our personal injury silo. It's the highest volume business to consumer silo that we have, as opposed to our no-fault silo, which is business to business. And the questions that we get from the general public, potential clients, and even clients are very repetitive in nature. People want to know the same types of information very regularly with regard to personal injury cases, right? Mm-hmm. So Jules was contacted last week. A lot of people email her. She's a point person as she does community outreach. And they were asking a question about their case. She forwarded it on to the appropriate party, but it spurred the idea to do a FAQ type of podcast. And I think it'd be very valuable to our existing clients, mm-hmm. which we will probably send out an email on. But it's also going to be valuable, I think, to potential clients when they're evaluating, do they need a personal injury attorney? Do they need to call an attorney at all? And the like. So thanks again for tuning in. I'm looking forward to this episode. So Jules, take it away.
Yeah, so I have a long list for you today. First and foremost, on our personal injury side, the most frequently asked question we get is, how do I know I have a personal injury case?
Okay. Sounds like a simple question, right? But we get called all the time and we need information when people call the office. So the first question that we have to ask is, are you hurt? And you'd be surprised how many people are like, no, I'm not hurt. I'm like, okay, injury to your body, personal injury, where you've been damaged as a result of negligence. Somebody did something or failed to do something that they should have done that resulted in you being injured is the basic analysis that needs to be done. So if you have a personal injury claim, in the beginning it's a claim, it's not a case, but you have a personal injury claim if, let's say, you're in a car accident or you fall as a result of a defect on somebody's premises and you're injured, right? That's the preliminary analysis. And that case is worthy of investigation, and that's our standard. Is the case or claim worthy of investigation? We will sign it up subject to investigation, run an investigation, and then proceed forward with a claim, and if necessary and warranted, litigation. So to answer the question is, the preliminary question starts with, were you hurt? And if the answer is yes, did somebody do something wrong, negligence, or fail to act when they should have? Also negligence.
All right. And the second one, because, everybody always loves to talk about money, is what is the value of my personal injury claim? Or how much is my case worth?
That is the single most asked question that we get.
Yeah.
It's usually in the first call, first meeting. People ask it all along the way. And I love the question because it's always the same answer. It will always be the same answer. It's been the same answer for me for 28 years. Somebody calls up, they say, hey, what's my case worth? The real answer is no attorney should ever say anything other than, there's no way for me to know that right now. I have to run an investigation. Mm-hmm. And just a little tool of analysis for the general public out there if they're evaluating hiring a personal injury attorney, right? And one of the goals of the podcast is to give away actionable tips and tools so that people know how to evaluate who they're talking to on the other side of the phone when they're evaluating an attorney. Any attorney that tells you, oh, your case is worth X in the first phone call with nothing in front of them, Jules, what's the rule?
Run. That's
Run.
a red flag.
It's a huge red flag. A lot of attorneys, and I disagree with this practice intensely, but a lot of attorneys will give you a value in order to get you to sign the case. It's just a cold, hard reality, right? Because once you're a client, the odds are you're going to stay a client, and they figure they can deal with whatever they need to deal with on the back end in terms of any difference between what they told you day one when they had no information in front of them and 2 years, 3 years, 4 years later on the courthouse steps. It's just not a practice that we engage in here. And I would tell anybody listening to this, the real answer is nobody has a crystal ball. No one can tell you what your case is worth until a full investigation is run. And any attorney telling you that, they're not being straight with the potential client. So if you hear that, you need to run. That's great advice, Jules.
Okay, next one that we hear all the time is how long do I have to file a personal injury claim? It is different state by state. So how long do I have to file a personal injury claim specifically in New York?
Okay, it also values case by case, right? So what you're talking about is a statute of limitations. Statute of limitations is a statute, a law that sets specific timeframes for filing personal injury cases. And I'm not going to give specific timeframes here because I don't want anybody to rely on this. This is not legal advice, but in many instances, it can be 3 years. But there may be a contract that was signed that shortens it. There are statute shortening contractual obligations that are valid, right? So you can contract away with whoever you're signing a contract with a certain amount of time to file suit just by signing a contract. Also, it depends on if there's a municipality involved, much shorter timeframes. So the answer is it depends. And the best, again, giving some tools, right? It's not advice, but it's tools to anybody listening to this is your best action is to move right away to go to somebody who handles personal injury. You know, our firm does personal injury. You call us up. We know the statutes of limitations once we talk to clients. We note the file. We advise the clients once they're clients. Go to somebody that does personal injury. And those statutes of limitations are well established and they should be able to give you guidance on it. The key thing is to act immediately because in some instances you might wait, 6 months to a year, and that might impact your ability, even though it's still a relatively short time frame. So yes, it varies state by state, but it also varies case by case and the underlying facts of the case.
Yes.
And I know I just did what everybody hates when it comes to lawyers, which is
it depends,
right? Yeah. So it really does. And there's a reason why lawyers say that, because it really does depend.
Yeah. And that's the answer to honestly most of these questions, but we'll get through those. So something that people always ask us is how long will it take to resolve my case?
My answer would be it depends, right? It depends on, I know, I'm lawyering again, but it truly does depend on a case resolution. How quick does the investigation go, right? In evaluating any personal injury claim, the 3 factors that can play into and determine how quickly it goes is 1, liability. Who did what wrong, period. If that's clear cut, then it's an analysis on damages, right? What are the extent of the damages, the injuries, both economic and non-economic? And the third leg of analysis is coverage. What people don't understand is that 99% of personal injury firms out there are not going to go forward without insurance coverage in place because of the costs of litigation. So you got liability, damages, and insurance coverage that all kind of play into the analysis of how long a case can go. Because let's say you have injuries that are worth $400,000, right? And liability is clearly established.
Yep.
Right? We know it's a car accident, not your fault, the other person's fault. But there's only $100,000 in coverage. You're going to secure a full policy, tender that, insurance policy very quickly. It'll resolve quick. But then you have cases where you have much larger coverage, right? I had a case with almost $2.5 million in coverage. I had a brain damage case 3 other plaintiffs. That case dragged on forever. Forever. It was like, I think we closed it out in 4 years, 3.5 years.
Would you say that's the longest case you've ever seen, or handled in office?
Oh, no. I mean, I know other people that their cases have dragged on 5. I've heard horror stories of 10 years. I don't know how they get to that length of time. To get to a trial right now, if it's hotly disputed and the carrier is not willing to pay, you could go 5 years to get to a trial. COVID really changed the speed with which cases were moving through the courts.
Well, that kind of brings us into our next question. A lot of people always wonder, do I go to trial with my case? How do I know I should take this to trial?
We use a settlement analyzer tool to show clients both the risks of going to trial and the costs of going to trial. Because, there are cases that should go to trial where you have egregious negligence, massive injuries, and a lot of insurance coverage, where the carrier doesn't think the injuries are worth what you think they're worth as the attorney and the client thinks they're worth. And the only way to resolve that dispute is through trial. So the costs of trial are significant. So we have to factor that into the analysis, show a client the risks, right? I read some statistics that 1 out of 2 cases results in a defense verdict. Now, I think that's still a pretty good statistic. That doesn't mean you don't go to trial on cases that should go to trial. And sometimes you get a disappointing outcome, but the clients have to be made aware of the risk. So if you ask the question to me, do I go to trial or do I accept a settlement offer? It's a complex analysis, right? Because in 4 out of 7 of the scenarios that can play out, I think it's 4 out of 7 scenarios, the client can end up with 0.
Yeah.
Or you get a verdict, but it covers all the trial costs and the attorney gets paid and you still end up with 0, right? So that's never a good outcome for the client. So we have to analyze the risk with the client. We do verdict searches that show potential outcomes, good and bad. And then we make an analysis together of what we think the case is worth. If you have a catastrophic injury case, those are cases that most PI attorneys will take to trial. Right? We do brain injury cases. Those cases, if we're not getting what the client deserves in terms of an offer from the carrier, which is usually a 7-figure, multi-7-figure policy tender, we're going to take it to trial. No questions asked. Not even going to mediate it. Just go to trial. Now, that being said, a lot of times they'll tender at the last minute. They'll pay the full policy. Clients have to be made aware of the costs of a real trial, right? Somewhere in the neighborhood of $100,000 for a full-blown personal injury trial, not uncommon. So I have a buddy of mine, took a massive injury case to trial. He had $500,000 in disbursements.
Yeah, that's crazy.
$500,000. Now the case, he rang the bell for a massive number. But clients just have to be made aware that it's not as easy as saying, we have to go to trial on everything. And I hear that a lot from clients, but I think that it's an education process, right? We sit down, we show them, here are the outcomes that can happen. It's like 3 or 4 out of 7 different scenarios. Like we put all the scenarios on a piece of paper for them. We show them, you get a defense verdict, you get 0. There's trial costs that are outlaid and none of your liens get paid. All of your doctors go unpaid, all of these things. And then there are other scenarios where there may be a small recovery from a jury verdict, but it doesn't cover anything going to the client because everybody else gets paid. The attorney's fees get paid. The liens get paid. Medicare, Medicaid, they get paid. Federal government always gets paid. So, once you lay these all out for the client, then we can all make an educated analysis of should we go forward to trial. And one of the more recent cases that we did, and again, I mentioned brain injuries earlier. So typically, if we have, let's say, 4 brain injury cases running at any given time and a couple of wrongful death cases running at any given time, right? Somebody died as a result of somebody's negligence, right? Or somebody has a permanent brain injury, brain damage as a result of somebody else's negligence. Well, guess what? Those cases are prepped for trial day one. Day one. And we start spending money on multiple levels of experts pretty much out of the gate, right? So in those instances, we tell the client, look, here's our opinion of what we think you're going to need to live on the rest of your life. So let's say, for instance, the one case that sticks in my head was a brain damage case that we did. It took 3.5 years to resolve.
Mm-hmm.
We were litigating this thing every inch of the way, tooth and nail, for the 3.5 years to fight for that client. Because I knew the client who was in his early 30s.
Yeah, he was young.
He needed this. Yeah, man, he needed this money to survive. So was I just going to take some BS offer from the carrier? No, it wouldn't have been the right thing. Would not have been the right thing. The right thing is telling clients that the carriers are trying to get away with some bullshit.
Mm-hmm.
Right? They're not paying you fairly. They're not engaging in good faith. And you know what the question that stops most carriers in their tracks when an adjuster is talking to you across the table? If this was your kid, would you be offering that same money? And they don't like that question. It makes them bristle because it personalizes it for them. You can't ask that at a jury trial in New York. You can't ask the jury to say, well, if this was your kid, what would this case be worth? But you can do it at a mediation to an adjuster.
Mm-hmm.
And I've done it in mediations we've attended to the mediators. When a mediator, because again, mediator's job is to make cases settle.
Mm-hmm.
So they want to put pressure on both sides to settle. So when they send the defendants out of the room and I'm in my 5th hour of negotiating and I haven't budged off my initial demand, I say to the mediator, hey, if this was your son, would you be pushing me to settle this case like this? And I had one get so upset when she walked out of the room, right? So on that one case, there was roughly $2.5 million in coverage, and there were 4 plaintiffs, including the one that we were representing. And our plaintiff was the most hurt. And without getting too deep into the numbers, because I don't love when people do these verdict alert, settlement alert, nonsense posts, we walked out with a lion's share of the money for the client because that's what we were supposed to do. And I wasn't budging. But we had prepped the case for trial, and I was ready to go to trial and open on the case. The carrier tendered all the money, and then I ended up fighting with 3 other plaintiffs' firms in a room over how the $2.5 million was going to get split up. But suffice it to say, my client took the lion's share of the money, as they were supposed to. And I did my job. So, in that case, this client was relying on me. He had a guardian. He had somebody who was watching over him the whole time. They were both immigrants, and English was their second language. And they were relying on me for everything. So I would literally sit with them for hours after the office closed and explain to them all of this stuff, with somebody who was translating because I wanted them to have an understanding in their primary language. And we spent hours going over the risks, the costs of future living expenses, knowing that this brain damaged client was going to need help, that his injuries weren't going to improve. So with that, I was ready to go to trial. And I was already 50,000, 60,000 in by the time we got to mediation because I had already prepped for the trial. My demonstratives were ready. The last piece of it was to get a video animation of the accident, which was going to cost another 20,000. I said to the client, if this doesn't settle, we're going to get the animation. We're going to get our expert to, get this animation in. We're going to do whatever depositions and fight whatever motions we have to fight. And then we're going to try the case. And I told the carrier, I'm telling you now, I put a bad faith letter in your file. You don't settle. You don't put up all the money. We're not settling with you once I spend the balance of this money.
Yeah.
And, they tendered. And again, I had 3 other plaintiffs' firms, and I was the one leading the litigation because they were all just relying on going to a mediation with a scrap of paper in their hand and doing some kind of fakakta negotiations. That's not how you approach this stuff. And the other client, one of the other firms had a fairly significantly injured client who was ejected from the same vehicle and broke all the bones in her lower body, basically. But when you did a comparison to my brain damage client on the scale of recovery, the scale of permanency, she was hurt. She wasn't hurt like my guy was hurt. So determining to go to trial is driven by the facts of the case. It's driven by liability. It's driven by, did plaintiff have any hand in his own injuries, which goes to a liability split or analysis on liability. And then the extent of the damages, the permanency is a big factor. At 31, this guy had economic damages. He couldn't work anymore, ever. So
he couldn't even do basic tasks anymore.
No, his language skills were diminished, right? His cognitive abilities were impaired. He had physical impairments. One part of it, one side of his body really didn't work. He walked with a limp and his one arm was kind of unusable. So this all goes into it. It all goes into it. It's not a simple answer it's not a simple question to answer. But again, look, I know firms take every single case to trial. These big monster firms, they have these big war chests. That's great. It's just that's not my model. It's not my business model, right? The cases that have to go to trial will, but there has to be an analysis done because at the end of the day, while you can have a couple of hundred to a couple of thousand of these files running, for that one client, it's their only case. And what's fair is doing an analysis that shows them everything, the costs, the risks, all of it.
Yeah, of course.
Sorry, that's a long answer, but we get that question all the time. I have a client now who wants a trial, barely treating, wants a trial. I'm like, listen,
it's never going to work.
We're not taking the case to trial. You're not getting the impact of what trials cost and your risks involved. And that's fine if that's what you want. There's other law firms that'll do it.
But not this firm.
Right.
This also ties into another question that we always get a lot, which is, should I accept the insurance company's first settlement offer?
The first settlement offer is no, never.
Absolutely not.
Right. But if you're analyzing, do you accept a settlement offer? Again, it comes down to a risk-reward analysis. And it's the flip side of, do I go to trial, right? So there are two sides to the same coin. What are the risks? What are the costs involved? And what is your risk tolerance? As a personal injury attorney, I have a very high risk tolerance, but I always have to put myself in my client's shoes to say what is best for the client, right? And it's all relative. When I hear an attorney turning down a $20 million offer on a case that he thinks is worth $100 million, and it's a paraplegic case, and the negligence is so gross, and there's a deep pocket that has $100 million in insurance, guess what? It's all relative. Yeah, you're going to spend $500,000 on that case. Comfortably, I would spend that kind of money on it. That doesn't mean it doesn't take a lot of guts to try that case, man. I give that attorney a lot of credit because he went to the mats for that client and he rang the bell for $107 million. So yeah, it's all relative. Again, you have your one end of the spectrum of soft tissue injuries that make threshold in New York, and then you go all the way to catastrophic injuries where you have, brain damage, brain death, permanent paralysis, that type of stuff. So as you go down the spectrum of seriousness, it makes it easier because of the extent of the injuries, as long as there's coverage there. So in determining to settle, it's the flip side of that prior question.
Okay, so another question that we get very frequently that kind of ties into the first question is, can I sue for pain and suffering?
Yes. In New York, you can sue for pain and suffering. It is a non-economic damage analysis versus economic damages, right? What are your lost wages, past and future? What are your out-of-pocket expenses, past? And what will be your predicted out-of-pocket expenses, future? Pain and suffering is just that. So the jury will be tasked with setting a value on just how extensive your injuries are and awarding you fair and just compensation for those injuries. And they do it all the time, right? So, take that brain injury case for a second, or a brain injury case, right? There is a certain symptomology that goes along with brain injuries. If lawyers that work them know, noncompliance with treatment is one of the symptoms, right? So you have to be able to explain to a jury what the arguments are that cut against that defense of, well, they're not really hurt, they didn't treat. But if you can paint the picture of just how extensive the injuries are, and how extensive really is determined by permanency, right? So when I'm looking at a brain scan or a brain MRI, and you see the brain bleeds, and you see permanent injuries, and then you see, terminology like axonal shearing, right? It's permanent, right? There's certain conditions there will be no recovery from. And so that pain and that suffering is extensive. Plaintiffs' attorneys try cases, they tell the jury what they think they're worth. Now, the jury can agree with them, not agree with them, or come in well over, right? They can come in lower, but they can come in higher too. So it really depends on how the cases go in and how the jury responds to both your client and the evidence that they are deciding on. So yeah, pain and suffering is a big element in personal injury cases in New York.
In personal injury cases, when somebody's injured and let's say they're out of work for a while, a typical question they always have is, who will pay for my medical bills and lost wages?
Okay, so again, fact specific, it depends. Because let's say for a second, it's an auto accident. Well, auto accidents, typically you will have first party benefits called no fault insurance or PIP, personal injury protection insurance in New York, with a minimum coverage of $50,000. And then some people buy more coverage with their auto policies, whether they know it or not, and they can have upwards of $150,000 in coverage, which is there to cover medical bills and basic economic loss up to 50,000, lost wages. And if they purchase more coverage, then they'll get more benefits in that event. The good thing about that kind of coverage is if you have more, right, it covers you regardless of fault. That's why it's called no fault, right? So I always encourage my clients, look, let's go through your declaration pages. Let's look at how much PIP insurance, no fault, are you currently carrying? And at least you can make changes down the road. Same thing with SUM coverage, right? Supplemental underinsured, uninsured motorist coverage. That insures you in the event that the person who hurt you only has a minimal policy or is uninsured. So I always tell people, you want to get the maximum you can afford under your auto policy. What the insurance companies don't tell you is, let's say you have $100,000 on your car insurance to insure other people if you hurt them under the liability portion. Well, you can buy $100,000 in SUM coverage for like $10 a month, let's say. They don't tell you that. They don't want to sell that because they don't make any money. And I tell all my clients, go max out your SUM to match your liability limits. So your medical bills and lost wages can also be paid by workers' compensation if workers' comp is involved, if you were hurt on the job. If there are no collateral sources, then you can also build it into your damages analysis during the personal injury case where you say, this is how much I'm out of pocket lost wages. This is how much I'm out of pocket for my medical bills. And you seek reimbursement from the third party carrier. And if the third party carrier doesn't voluntarily settle it, you'll ask a jury to award those on top of pain and suffering, past and future, on top of, all the other levels of damage that go into a jury verdict request.
And finally, people always want to know, how much does it cost to hire a personal injury lawyer?
I think everybody knows the answer to that question, but because it's on every TV commercial. In New York, it's a standard 1/3 legal fee. And if there's no recovery, there's no legal fee. So it's not free, though. I always tell clients, listen, you're eventually paying me, but it's on the back end and you may not feel it because it's coming from an insurance settlement or a insurance pocket to satisfy a verdict, but you are paying me. Make no mistake about it.
Yes, we don't totally work for free.
No.
Well, in some cases, you would put work into a case and let's say there is no financial recovery there, then in that case, we don't get paid.
That's correct. No recovery, no fee. That's exactly it. And, I think that the big skill in what we try to do is analyzing risk reward analysis for the business side of it, right? How many cases do you want to get zero on? None. So you want to be analyzing early and often every case that comes in systematically, risk, reward, liability, damages, and coverage, risk, reward, right? And that's the key to not only surviving as a personal injury lawyer, but thriving as a personal injury law firm. Everything we do is contingency based here.
Well, not everything, not every silo.
Almost every silo. We do have a couple of non-personal injury breach contract cases you're talking about where if somebody's being sued, it would be an hourly. But there is still a contingency component to what we do in that silo as well.
Yeah.
But the majority of the revenue that we make is contingency based. You got to be really good about analyzing cases early and often. That's it. Those are the most commonly asked questions that I get. I didn't know if you had anything else.
No. If anybody has any more questions, though, feel free to leave them in our comments or email us. Or a lot of people forward us questions on social media. You can find us on TikTok, Instagram, Facebook. You could always send us a DM, and it's always most likely Tom or myself answering. So if you guys have any other questions, feel free to ask us.
Yeah, I think the big takeaway for everybody here is there is no way somebody who doesn't do what I do or what we do here would ever know the answers to these questions, right? So I think the key is to act quickly. And when you're interviewing personal injury law firms or lawyers, you can ask these questions, but really pay more attention to the answers, because the answers I just gave you are a good guidepost. And the biggest takeaway is if anybody tells you what your case is worth in that first phone call or the first meeting, they're not the right attorney for you.
Most good attorneys will say it depends to almost every question you ask.
Because it does. It's fact specific. I want to thank everybody for tuning in, and you can ask any questions you want going forward. We'll do what we can to get them on an episode. And please find us where you listen to podcasts, Apple, Spotify, Google, and please leave us your feedback. Leave us a 5-star review, share it with anybody you think you'd find this episode helpful, and find us anywhere that you listen to podcasts. Thanks for tuning in. We're out.
Thank you guys. Bye.
Bye.